Hello everyone, welcome to our talk. I'm Mang Cai, PhD, JD, attorney at law at New Weiming Law Group. We are located in Washington, D.C. metro area, and we have obtained numerous approvals for our clients in their immigration petitions. My topic is frequently asked questions for O-1 visa. Well, first, why any applicant, the company and the beneficiary will need the O-1 visa? Well, O-1 is a work visa. It provides an alternative to the H-1B visa. There are certain advantages of O-1. Specifically, there is no quota limit, so there's no lottery system needed. Also, there's no prevailing wage requirement for O-1, which is different from H-1B, and this may work for certain employers who face high prevailing wage requirements for the H-1B petition. Also, because there's no lottery requirement, O-1 application basically can be submitted any time of the calendar year, whenever the petitioner, company, employer, or the beneficiary individual are ready. Also, the beneficiary can start work for the employer right after approval of O-1. In contrast, for H-1B application, the application may need to be submitted, say, in the first week of April, and then there is the lottery process with some uncertainty. And even the case received approval, the beneficiary still must wait until October 1st in order to get the H-1B visa status. There is no such waiting for O-1. Also, O-1 applications can use premium processing. As we know, for H-1B, premium processing is an on or off scenario. Sometimes the USCIS will announce because they received a large number of applications, there will be no premium processing available for H-1B. This happened in 2018 and also in 2017. There is no such restriction for O-1, at least now can always use premium processing. And finally, O-1 also has a relatively high approval rate. For H-1B, recently the approval rate dropped significantly and is hanging around 60%. For O-1, the approval rate is more than 80% if you submit the application to the West Coast, to California Service Center, and it is around 90% in the East Coast at Vermont Service Center. So these are the differences between O-1 and H-1B and advantages, which answers why some beneficiaries and petitioners prefer the O-1 visa. Then the next question, who may qualify for the O-1 visa? There are O-1A and O-1B. O-1A visa is for researchers, scientists, engineers, physicians, professionals. O-1B are mainly for artists in performing arts and for coaches. So both O-1A and O-1B are in the so-called alien of extraordinary ability category. So the beneficiary will need to provide past track record to show how he or she meets the requirement. Next question, what kind of employer can support O-1 visa? Different from the requirements to the beneficiary, requirement for employer is relatively flexible. The employer can be a company, or can be a research institute or university, or a non-profit organization. It can be a large company or a small company. Basically, we can say that as long as the employer is qualified to submit H-1B application, the same employer will qualify for O-1 petition. Of course, the employer will need to provide certain financial documents or its equivalent to show the employer has sufficient financial means to pay the proffered wage. And of course, this position, the job offered, needs to be a professional job, that meets the background of the beneficiary. So it can be like a research job or a job in performing art, etc. Next question, what documents are required for the O-1 visa? For O-1 application, the form to be submitted to the USCIS is called I-129. There are also supporting materials to establish the bona fide employment relationship and the existence of the employer as petitioner, and that the employer meets certain requirements, and also the beneficiary qualifies for O1. In addition, there is the application fee of $460 for O1. And as we mentioned, there's also the optional premium processing option for O1, which the USCIS charged an additional $1,225. Next question. Well, for the beneficiary of O1, what about their family members? How do they add the family members to the petition? There is an O3 visa status for the family members, for the husband, wife, or children of O1 holder. In order to apply the O3 visa status, a separate application with the application form number I-539 is required. And the O3 visa holder, they cannot work under the current law in the US. Besides O3, there is another visa called O2 that is for assistance of O1. For example, if the O1 visa holder is an opera singer or a magician, there needs to be assistance for the performance, and these assistants can apply and receive the O2 visa. Then the next question. We have compared the advantages of O1 to H1B. Then how about the procedure and the difficulty to get O1 approved compared to H1B? In general, as we mentioned, O1 has higher approval rate and should be easier to approve than H1B. In addition, O1 costs less to the employer. For H1B, there are certain fees associated, like anti-fraud fee and also fees to train American workers. These fees are not required for O1. So in general, we can say the procedure is simpler for employer for O1 application compared to H1B, and the cost for O1 is also lower. So overall, it's more convenient and can be more preferable for the employer. Well, on the other hand, the employee, the beneficiary, needs to prepare and submit more documents compared to H1B, because O1 is for individuals of extraordinary ability. So in addition, the beneficiary also needs to provide additional document to evidence to show that he or she does qualify for this alien with extraordinary ability standard. However, the work is usually not spent in vain, because the same materials can also be used later for the beneficiary's subsequent green card applications in the NIW, National Interest Waiver, EB1A, Alien with Extraordinary Ability, or EB1B, Outstanding Researcher petitions. So the beneficiary should be better off with the preparation of the O1 petition. And as we know, some employers, they may be hesitant to sponsor the green card application for their employees from the start, from the very beginning, because they have legitimate concerns regarding job stability, how long the employee may stay with the employer. On the other hand, O1 is work visa. It mainly benefits the employer instead of the employee. So more employers should be willing to apply O1 for their employees. In reality, we have seen that many employers, they are reluctant in applying O1. This frequently is because the employers are not familiar with the O1 process. And when the employer learns more about O1, most likely they will be more willing to support the O1 for their employees, for the beneficiaries. Finally, how can you get more information? You can contact us. We have abundant experience in handling O1 applications and receive approvals. We have obtained approvals of many cases. And in fact, we have personal experience in O1 application. One of our own co-workers received O1A approval sponsored by our law firm. And that was several years ago. And she has been using O1 visa to work with our law firm since then. And recently, we filed O1 extension for this individual, and the O1 extension was also approved smoothly. So that's all for the talk. Thank you.